Hello, I'm David Schraga, Secretary of the Beverly Hills Bar Association's Entertainment Law Section, and thank you for joining us. We have a fantastic program for you with an exceptional speaker who will be talking to us on the topic Beyond the Merits, Legal Disputes from the Executive Perspective. But before getting into our seminar, we wanted to take a moment to acknowledge Lawyers Mutual Insurance Company, who graciously supports the Entertainment Law Section. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that Lawyers Mutual is directed by a group of dedicated lawyers themselves. They offer special rates with competitive premiums for a wide range of areas of practice, including entertainment law, and you can learn more about them at lawyersmutual.com. I can also say firsthand that they have great people on their team who are true experts and have presented to our section before, and we are very grateful to have their support. I am delighted to now introduce our speaker, Michael Schwimmer. Michael Schwimmer is a commercial mediator and the founder of Schwimmer Mediation, where he brings a rare blend of experience as a lawyer and corporate executive doing business in the US and abroad. A former CEO and senior executive in major media companies, Michael draws on decades of high-stakes negotiation and conflict resolution across such diverse areas as intellectual property licensing and distribution, investments, partnerships, M&A, finance, corporate governance, and employment, among many others. Michael offers parties a pragmatic, business-first approach to resolving complex commercial conflicts, and we are very fortunate to have him speak with us today and offer his uncommon and truly invaluable perspective. As you'll see from his presentation, he offers insight into what business executives in-house are thinking about, what they want from their outside counsel, and how to service these valuable relationships. And of course, he does it all from the perspective of someone who has actually been a lawyer on the front lines of these disputes as well. So with that, I will thank Michael again for sharing his expertise today. And now let's get started.
Oh, great. Thank you, David. That was very kind words. I'm really happy to be here today. Thank you for you all for having me, for showing up. A little bit of housekeeping. I really encourage Q&A. If it's something that's germane to what I'm talking about, please jump in. I'll try to see it and talk about it. If not, please make sure to ask some questions so we get it a little interactive at the end. My goal for today is, as David said, to provide insight into what business people, managers, CEOs, vice presidents, whoever are thinking about when there's a legal dispute. I think a lot of what I'm going to talk about is also applicable to transactional lawyers, but today's context is largely in the dispute context, whether there's been an actual lawsuit filed or not. The caveat that I want to make is this is not a rejection of advocacy, a rejection of deep analysis of the merits at all. It's more of a framing so that counsel, whether the outside counsel or in-house counsel, can see disputes as an input into a broader context where the decisions ultimately get made by business folks based on criteria that may not always be obvious to counsel. Just a minute on how I came to the topic, how I come to the topic. It's a topic that interests me enormously because it all comes from my own personal experience. I started out very, very briefly as a young litigation associate in San Francisco. And then pretty early on in my career, I moved to Brazil and practiced transactional law for a multinational law firm. And I found that I was much more interested in what my clients were doing than maybe what I was doing, and that of course led me to go in house. And I got closer to what I would call strategic business decision making, but I was still not there in the sense that when you're outside counsel, it was, hey, we need you to file this lawsuit or defend this lawsuit. When I went in-house, of course, there were deals, there was litigation to manage, but it was only when I moved over to the business side that I began to have responsibility for a broader set of interests. be that growth, profitability, operational stability, strategic initiatives. And when I did that, what I found was that I began to think about legal disputes and transactional deals in a different way. As opposed to being the sole focus of what I was trying to get done, they were a piece of the puzzle that fit within a larger picture. And that led me to thinking about the lawyers that I wanted to work with differently, thinking a little bit differently about what I valued, and that's kind of what leads to today. And hopefully, I'm able to provide some insight that is useful for you that are here today. Now I'm going to try to share my screen. Give me 1 second here. And let's see. Let's share. And there we go. Okay. So here we are. And beyond the merits, the executive lens on legal disputes. So the building blocks, of course, for lawyers is how we were trained. It's how our legal system works. You gather up all the facts, the good ones, the bad ones. You look at how the law, applies to those facts. You work really, really hard as an advocate to increase the likelihood of success, no matter which side of the dispute you're on. And and there's obviously incredible skill and craft in doing all of those things. From an executive perspective, of course, there are different building blocks, but building blocks nonetheless. And the first question that comes up when there's a dispute is, what's the level of impact that this dispute could have on my business? Is it small and relatively immaterial? Is it sort of life-threatening, if you will? So you're just trying to gauge, how much time, how much focus, how much resource does this particular matter? How much does it deserve? Power dynamics is something that we're going to talk about a lot today, but fundamentally, that's just is this an opportunity where we can flex? Do we need to put on our body armor because we're at serious risk? And who really has the leverage in this dispute? And last, there's risk, and how do you size that risk, and what does it mean ultimately to the company? Let me give you one sort of example. I'll give you a few, war stories, if you will. There was a time when I was a CEO of a cable network. It was a small cable network. We were venture backed. We had a contract with a large satellite distributor, and they paid us about $1 million a month. And $1 million a month for us was massive. And one day the monthly check came in, and it was zero, right? And the paperwork attached to it said, amount owed $1 million, credit taken $1 million, check equals zero. And when we dug into it, what we found out was they had gone back into the contract and found what they thought was a sufficient ambiguity to say that they had overpaid us in the past and they were taking back a credit of $1 million. And the fact is, we looked at it, our lawyers looked at it. There was no real ambiguity in our view. It was pretty crystal clear that they owed us the money. But the fact of the matter is, we weren't, after we fought about it but didn't get anywhere, meaning in conversations, there really just wasn't a scenario where it made sense for us to file a lawsuit. They were one of our largest distributors. We had a renewal coming up in less than a year. They didn't have to renew the contract. And so from a commercial perspective, even though we were right in every imaginable way that they owed us the money, the fact of the matter is we really had to swallow really, really hard and just move on, because the commercial dynamics meant that the merits in this case just didn't really matter. We had to preserve the relationship, and $11 million for that year instead of 12 was a lot better for us than getting in a huge fight that would lead to a non-renewal later on. So what are some of the things that executives think about. It's not an exhaustive list, but it does explain a lot. If you look at each of these items, and we'll go through each one separately. If you look at each of them, they can explain a lot of what's going on inside your client's head, inside their company. They're what I would call the components of a commercial ecosystem, and every industry has an ecosystem. I don't care if you're selling burgers on a corner and your commercial ecosystem is who's selling you the meat, who's selling you the buns, how many of your competitors are down the street, or if you're a large movie studio. We all live within a commercial ecosystem, and that ecosystem is made up of people that supply us things we need, people that buy our product, competitors, so forth, and so on. And these are the things that really, in a very strong way, impact how executives are going to think about a dispute when it comes up. So let's start with power. Power is one of those weird words in society where, we don't talk about it a lot, but it's there all the time, and it's not a moral concept. It's just sort of a human attribute. I would call it the single most important thing that I learned over the course of my career is how ultimately um, finding who has leverage is largely determinative of the path something is going to go and how people engage and what they're willing to do and what they're not willing to do. And so finding out who has the leverage and why they have it. And I'm not talking about leverage from a legal perspective. I'm talking about within the commercial ecosystem in which these companies, because I'm largely talking about commercial disputes between two companies, who has the leverage within the commercial ecosystem in which they're operating, and we'll talk about what kinds of leverage there are, of course. But the important thing to remember is that it's not the lawsuit that creates this leverage. This leverage is endemic to their existence, to their presence in the market in the moment. It's independent of the legal merit. So finding out who has the leverage and why they have it is critical to understanding how executives are going to think about any given dispute. So one way I think about it is because here's the thing that leverage is one of those things that if people don't walk down the hall of their company and say, there's a dispute and I have the power and I'm going to exercise my power. I think it's something that is much more subconscious. It's part of, like, not to be too philosophical about it, it's part of the human existence. Exercising leverage is rewarded, and in business, it's rewarded largely in the form of market share, increased profits, and absent a legal restraint. One could think of, say, antitrust law as a legal restraint. Absent a legal restraint, people are going to exercise probably about as much as they can. And one could even argue that in a capitalist system, that it's required that they do, that the shareholders will require that they exercise that leverage. But at a very, like, simple level, I always come up with this image that pops in my head. If you give somebody a Ferrari and you say, there's no speed limit, like, how fast do you think they're going to drive, right? And they're just going to go fast. And the fact that it represents a danger to other people on the road is not necessarily going to make them go a lot slower. And it's an advantage that people have when they have leverage. And in my experience, it is even if it's subconscious, it's going to be used. So let's talk about common sources of leverage. If you think about size, I guess people could think about, well, it's a big company or it's a small company, and then there's the relative size between the two. If you have two large companies, I was a long time in the pay TV industry, and I worked for a Fortune 500 company back in the day, Dish Network, and we were always fighting with other programmers, and some of those were from very, very large media conglomerates, and we both had the resources to engage in whatever legal battle we wanted to. So the size of the company was not really an advantage for either one because we were both large. On the other hand, you can imagine situations where it's disparate. Every once in a while, there'll be a situation where being small actually has an advantage. Um, that can be when there's, a regulatory element to that where, whether it's the FCC or the DOJ, they don't want to see a larger company beating up on a smaller company. So maybe being small has an advantage in that case, but usually scale, denotes bank account and the advantage that that comes with. Where I think it gets more interesting is when parties have a vulnerability in relation to each other. So the best way to think about it is, you have a buyer or a seller. I have some other examples here. IP reliance is a big one. But if in any dispute, you can sit back and look at the facts, and if you really understand the business of both parties, you're going to see pretty quickly, where the leverage lies. And so again, this is all before you even get to the merits about who's right and who's wrong. Um, in my past, there was a situation where we got in a fight with Viacom when Viacom owned CBS, and they owned a bunch of cable networks, including MTV, and they threatened to take down all the channels off of our satellite system. And we thought we were in pretty good shape because at the end of the day, we had hundreds of channels on our pay TV platform. Football season was over, so we didn't have to worry about people not getting their game on CBS. And when those channels came down, and we happened to be in the middle of an antitrust lawsuit, and that's why it's germane to this conversation. Um, when the channels went down, all of a sudden our phone started ringing off the hook, and it was mothers who were complaining that we had taken SpongeBob away from their kids because SpongeBob was hugely popular on a network called Nickelodeon, and we didn't even realize the kind of leverage that they had over us based on the loyalty that show had in people's households that had small children. So, sometimes you don't know where the leverage is, and it appears later. And that was certainly a case for us. So the other thing is stakes. So after you get through like who has the leverage, like what are the stakes? You have to be able to size them both from an opportunity perspective as well as the downside, depending on which side of the dispute you're on. Obviously, if there are no real stakes for either party, then you're probably not in a dispute to begin with. It got worked out between a couple of folks over a phone call. But if there are real stakes, those stakes can be financial, which is sort of the most obvious one. Um, and when there's a lot of money involved, then everybody's all over it, right? Because it's a lot of money. But realize for smaller clients, for smaller businesses, what might not seem like a lot of money could be really existential, right? So the financial element obviously is in relation to any individual business. Um, but low dollar number, sort of low, how can I put it? You might have a case where there are low dollar numbers, but there's something very strategic at play. And that often happens when you're in the beginning of a new market, if you will, a new initiative where the business growth isn't there yet. It's not a robust, large division of a particular company, but it's something important to them. It's something that they want to lean into, and so you can find yourself in a dispute where there isn't much money at stake, but there's a lot of strategic value at stake. If you look at sort of this list, obviously when competitors are suing each other, that they want to put the other company in a disadvantageous position for their own advantage. That tends to be pretty clear from the outset. There are precedent issues, of course, as well, and there can be large precedent issues, as you can imagine, in things like class actions, a lot in the entertainment industry. When you have studios that are dealing with a lot of the same players at the same time. Those could be agencies, those could be talent, those could be distributors. So even though the dollars might not be that large, it may be that breaking the way they're doing business in this case is going to have ripple effects, which are just not how the company wants to do business going forward. So again, the stakes pretty important in an executive's mindset, if you will, is how hard do we fight about this? Is it worth going all the way to the mattresses, or is this something that we should settle quickly and reduce our risk in order to make sure that we can preserve the value that we want to, especially as it relates to things like precedent or reputation or competitive position and so forth. So you have the relationship between the parties, right? So that's that's a whole different angle, right? Like who's on the other side and what's your relationship to them. So if there's no prior relationship, then generally, that's not going to be a huge factor in how people think about their engagement with the dispute, how hard they lean in or not, because there's somebody on the other side of the lawsuit that they're not in an ongoing relationship with. This can be a situation like, IP infringement, where the infringer is somebody that you're not doing business with, or vice versa. It could be real estate, where two companies are both claiming to have an interest entitled to a piece of property. They haven't done business together. They could be two banks with competing, collateral or what have you. So it doesn't mean that it's not an important case for them and that winning isn't important. What it means is there isn't a relationship there that they have to worry about preserving, and that gives them a lot more flexibility. Um, in ongoing relationships, and this is again, as I was talking about, very, very common, especially in the entertainment industry, because you have so many players that are constantly doing business together. So when I was at Dish and later when I ran Sling TV, we had hundreds of channels and hundreds of people that we did business with really like every day in a way by distributing their content out to millions of customers. And disputes would happen. Sometimes lawyers would get involved in working those disputes out. But that was all in the context of a relationship that we still needed to maintain on a day-to-day basis. And there were managers within the company who were still communicating with the other side, who were still working on new initiatives, sometimes new marketing initiatives, even though we were involved in a lawsuit. So that's a very different kind of situation where it dramatically affects how I would ask counsel to engage, because winning and losing may have been important, but it's balanced against making sure that we continue to have a strong operating relationship with the counterparty. You have you have situations where you've done a deal with somebody, so theoretically you have a relationship with them. You don't have a long history with them. It was the only deal you ever did, and unfortunately, it went bad. But the question there is, do you expect to do business with them in the future? Would you like to do business with them in the future? And so there's a situation where the impact of the value of the relationship and how that affects how you think about it. It could be low, it could be high. It just depends on the situation between the parties and whether or not they have an expectation of doing business together in the future. So again, another what I would call slice of the criteria that the business managers are thinking about. So existential risk, it's not it's not that often, but you can imagine that there are disputes where if one party loses, they can go out of business, right? It's that serious, whether it's because of a financial issue or a strategic issue, or maybe it's IP related, and it's going to take away their ability to use or sell a very core part of their value proposition. And so, in situations where there is, severe threat to the enterprise, I guess what the best way to put it is that, all bets are off, right? That the things that I just took you through, they kind of fall to the wayside because you're in survival mode, right? So the executive is going to think about things differently if there's that level of risk to the enterprise. If you win and there's a and the relationship is damaged, well, you're going to have to pick up those pieces later. But picking up the pieces later is a better alternative than losing. Than losing your business. So existential risk, again, it's worth understanding if whatever dispute you're involved in advising on rises to that level. So this is kind of a favorite of mine. I wouldn't put it at the top of the list along with power dynamics and stakes and relationship, but I think, we live in a world where we're part of communities inside our company, and in the commercial ecosystem in which we operate. And I've been in both large companies and smaller ones, and in which, there were lawsuits going on. So what is the impact that these disputes have from a cultural perspective in the smaller environments? Say when I was running a couple of cable channels, what I found to my surprise is that the fights really galvanized everybody's obviously super aware of it, because in a smaller company, and I think at the time maybe we had 100 people, but in a smaller environment, word travels very, very fast, and everybody knows we're either suing somebody or we've been sued, and it has this really fortunate effort of bringing people together, like, oh, we're going to beat those guys and let's work hard and let's get everything we need to get together for council to help them. And I found that I could use the fact that we were in a lawsuit to really create quite an esprit de corps and a sense of, underdog, embattled, and that paid long-term dividends in terms of making sure that we all stayed together and had each other's back, that kind of thing. But the downside, of course, is that people get nervous. And when you're not part of a larger company, people know that they feel that they're at risk. If it looks like there's a lawsuit that could, significantly damage the company, then especially folks who are, younger, maybe they're just buying a house or they want to buy a house or they have small children, and all of a sudden they're like thinking about, oh, what happens if we lose this lawsuit? It's not great. I've seen people leave for larger companies just because they didn't like what I would call the risk profile of that kind of an environment. Um, at an external perspective, well, before I go there, on an internal perspective, I would say if you're part of a larger company and there are a lot of lawsuits flying around, you just don't want to make sure that your staff, your employees think of you as a bully, right? No one, people these days, they want to be proud of where they're working, and they certainly don't want to go home feeling like they spent the day, beating up on a bunch of other folks, when things could have been worked out differently. So there's a bit of a downside there, but not nearly as clearly as when in a smaller corporate environment. From an external perspective, there is such a thing as a litigious reputation. I think every industry, knows, who are the folks that tend to work things out when things go sideways, and you sit down and you work things out. And even if lawyers get involved, you're still trying to work it out. And then who are the companies that are, the first chance they get, they're filing a lawsuit, right, to gain an advantage, and put pressure on the other side. And the downside to that, of course, is that it has an impact on contracting going forward. Because if you're one of those companies that has a reputation of being in court a lot, then as you do deals going forward, folks are going to say, well, I need to make this indemnification clause from, a paragraph to 3 pages, or, I'm kidding, but you get the idea that the drafting can get a lot tighter when there's less trust, that you'll be able to work things out on a friendly basis. And things like partnerships, marketing partnerships, joint ventures, those things, where there is a lot of trust involved, become harder, because especially in those sort of collaborative relationships, no matter what's written on the contract, you still need to be able to trust the other side. So this is where I think culture and reputation is sort of really an important factor for executives to think through as they are thinking about litigation strategy. So how does this all sort of show up in real life? I think it shows up with things that you see happening. So you think you have your client has a really strong claim, and the next thing you know, they want to settle. They want to settle quickly. They want to settle early. They're not maximizing their leverage. Well, why? Well, there are reasons why, and my bet is, in many cases, it will relate to some of the things that we've already discussed. Why are people fighting for years over modest dollars? Maybe it's ego, but maybe there's something else involved that is more strategic. Again, these things are largely independent of the merits. That's hence beyond the merits. And why are people escalating, right? Or not escalating when they could. So here, I think the issue is, if you're outside counsel, to a company, and you're seeing your client make decisions that don't necessarily align with the strength of the case or what you would normally expect, then you don't want to be surprised, right? And so I believe, like, a deep understanding of your client's business and what's important to them will avoid what I would call surprises and allow you to be much more attuned, to what's going on. So so let's talk about settlement mediation for a second. So obviously, the vast majority of lawsuits never go to trial. I think I heard it's somewhere well above 90% don't. And so that means they're going to settle, and they might settle, sometimes even between the parties, just getting together in a room and talking about it. But they're often going to settle with the help of counsel, whether that's directly between counsel or in the context of a mediation. But the key here is, before settlement discussions, before mediation, you don't have a lot of visibility into what the business dynamics are. And the reason is because you might have some nasty letters between the parties. Those are going to largely be for positioning purposes. You're going to have pleadings. Someone filed a complaint, someone answered a complaint, discovery, a bunch of interrogatories, some requests for admissions. But those are all very formal in nature, and none of it is confidential. And so the mediation is really the first place where the underlying power dynamics come front and center. And the business context is really where much of the action is happening, because in a settlement conversation, in a mediation, it's not about advocacy in the sense that it's much less about arguing your case, or why you'll get a summary judgment, or why a particular case applies or doesn't apply. And so effective counsel, in my view, is going to come into that environment, deeply embedded in their client's business thinking, because that's where it's going to matter the most, is in a settlement conversation. Advocacy itself, which is what litigators are great at, is just not as important in this environment, as quite frankly, deal making. And it's really an opportunity for counsel to become a creative partner. And in order for you to be a creative partner, you really need to understand what your client's thinking and what they're thinking from a business perspective, of course. The confidentiality of the environment is what really allows that to happen, whether it's under Rule 408 of the federal rules or whether it's the confidential mediation agreement. But at the end of the day, when people can speak freely and they're sitting down in order to get a deal done, that's when these underlying criteria, these underlying dynamics are really going to come to the forefront. So let's talk very, very briefly about boards of directors. Well, they come in all shapes and sizes, but they have a fundamentally different role than management, right? A board of directors is it's an oversight role. It's a governance role. It's not an operational role, and their job, is not to do everything on a day-to-day basis to grow the company. And so they'll come at disputes with a different focus, primarily an investor focus. How do we preserve shareholder value? Realize typically no one on the board was involved in whatever led to the dispute in the first place. So you don't have personal egos involved, like sometimes a client may want to prove that they're right. Well, because maybe they made the decision to do a particular deal. But once it gets to a board, by definition, it's material, it's a big deal. The board doesn't have a personal stake in the outcome. There isn't an ego, and they certainly don't have an incentive one way or the other. It's not like they're going to get paid more or less. They don't have a bonus that's going to depend on the outcome of this case. Whereas management obviously arrives from a very, very different perspective. So it's helpful to understand if your client is bringing something to their board, because that will explain both, one, you can help them position it, of course, and two, it may explain while there's can be a different negotiating posture or a different litigation strategy post discussion with a board as opposed to before. And that's because a board may have brought a different, what I would call, viewpoint, a different temperature, a different rationale that it wants management to move forward with. So, so what does all this mean from for business lawyers? And again, I think this is both useful for transaction lawyers as well as litigators. But it starts with having a deep curiosity for your client's business, and really understanding the industry that they live in, and how it all works, and how that impacts the context of this particular dispute that you're connected to, or deal that you're doing. Um, Having expertise in what you do, super important. Having strong skills, really important. But I would go so far as to say those are table stakes. Like if you're an expert at what you do, great. Those are table stakes, because theoretically every client wants to know that their lawyer is an expert. The differentiator is not that you have great subject matter expertise. The differentiator is that you deeply understand your client's business, and that you deeply understand what they do on a day-to-day basis and how they think about this dispute and the criteria that they're using in order to determine what the best strategy is going forward. And if you are able to communicate that as you work with your client, that can be a foundation for a tremendous amount of trust and loyalty that gets built between you and your client. I have a little bit of a ending caveat here, which is what we didn't talk about is the role of in-house counsel, because a lot of times outside lawyers are not really working directly with the business managers. They're working with in-house counsel. That brings obviously a different element to it, because in-house counsel sits in between management and outside counsel, and there's some translation that goes on, and they have a tricky job for sure. But that would be like a whole other hour of sitting here and talking about being an in-house counsel. I've been one working with in-house counsel as from an outside perspective, which I've done, and working with in-house counsel from an executive perspective, which I've also done quite a bit. I would say that a lot of folks that have run businesses, they don't come from a legal background. And so, it's pretty often for someone to ask their general counsel or ask their VP of sales or what have you, go talk to the lawyers and come back to me and tell me what you think we should do. I never did that. I loved working with lawyers. People would say, "Oh, you left the practice of law, so you escaped," and I that just never resonated with me at all. I was I have enormous respect for lawyers, and I enjoy working with them. So what I would do is I would ask them to come into my office. I'd say, okay, no, let's bring the lawyers in, bring the in-house counsel, bring the outside counsel, and let's all sit down and talk about what's going on and what this means for the business and how we can think about working on this particular problem going forward. So this is all very like personal to me in the sense that it was part of my day to day for many years. I enjoy it a lot, and I hope I was able to provide some useful concepts for you guys to think about. So with that, I am going to stop sharing my screen and figure out how to do that. There we go. Okay. So, hi, David.
Hey, Michael, good to be back. Thank you very much for a fantastic presentation, really tremendous insights. I wondered maybe I could follow up with you and ask a few questions that occurred to me
Sure, sure.
along the way. Backing up a little bit, one thing I thought was so interesting was when you talked about that circumstance where there's ongoing litigation between two businesses that are still working together.
Yeah,
Imagine it can create some really thorny situations both for the business and for the lawyers. I mean, in your experience, how would you like to see as the outside counsel, the litigator, navigating that with the internal business people as the person in house? How are you communicating between the business and the lawyers about what's happening? I mean, is it an ongoing dialogue? I can imagine there can be a disconnect. How do you manage the potential
I,
situations?
it gets a little complicated, but I think what you try to do, what I've always tried to do is what do they say in banking? You have that Chinese wall between like the analysts and the traders. For me, it was you sit down with the business folks and you say, hey, your day-to-day job is largely staying the same. You're going to work with that company. You're going to keep working on the projects that you've been working on. You're going to maintain that relationship. And if anybody asks you about the lawsuit, it's like, yeah, the lawyers are working on that, right? You don't want people who are quote unquote on the line, you know, serving the food every day to be involved in what's happening back in the kitchen, right? There is that relationship. It requires you know care and feeding, and if you treat people, my view is if you treat people with the same good attitude that you treated them before, then you can bifurcate those things, and the fight can go on in parallel, with senior level executives and counsel in-house and outside counsel working through the problem without affecting the day-to-day relationship that goes on. What you don't want is you don't want folks um, at what I'll call that on the line operational level trying to figure out what they should do based on the litigation.
Hmm.
Right, because they're not really equipped to do that unless they got specific instructions. So the best way is like, hey, let's you know just keep that separate. If you have any questions, come back to in-house counsel, come back to your business manager, and we can answer whatever questions you have. But don't try to work it out in real time with your someone else on the other side who also is in the same position, has no authority to figure anything out with you.
Well, and it's interesting because I think of it from sort of the litigator's perspective sometimes. All right, well, I would think there might be some intersection. Somebody's going to have a deposition taken or something like that. So I would be worried about, as the litigator, am I throwing a bomb into the middle of something that someone in the business has to deal with? But it sounds like, for the most part, you're really trying to insulate that process.
Yeah, no, you want to look, the business is it's a living organism, right? It has to operate It has to operate in a healthy way, and so you can't, that living organism needs to keep doing what it's doing. And if there's some adjustments, so we're not going to provide them with these marketing materials anymore or whatever, then there may be some certain adjustments that get made. But for the most part, the dispute is sort of severable from the day-to-day operations.
Interesting.
Unless it's like we're not supplying. If the relationship is completely broken down, so you're not supplying them with the software anymore. Well, then there isn't the relationship to maintain because the relationship literally blew up. But I'm thinking more about my experience where I'm going to make it up. If you had a restaurant and a food service company, well, the restaurant's still in business. They still need the product from the food service company, and they got to keep deliveries going and keep pushing the food out to the customers, and whatever dispute they have on something else, they'll figure that out.
It makes really good sense, especially when you're talking about larger businesses where it's not necessarily the core stakeholders who are going to be involved in the day to day in
Yeah.
the same way. I had another question for you that I thought was really interesting. You mentioned, when the board enters and the dynamic that exists in these companies with the boards. And I think for many of us, it might be a bit of an opaque relationship in terms of how the lawyers and the management executives interact with the board when a dispute like this comes up. I mean, what's your perspective on when the conversations happen, what conversations need to happen, what's the best practice in terms of how management works with the board to escalate disputes or to navigate them, to insulate themselves, to engage outside counsel at the right time? What does that dialogue and partnership look like?
Well, look, I think it all starts with where does the dispute fit in the business itself, right? So there's this concept of materiality. Certainly for a publicly traded company, the issue is this matter material? If it's material, that tends to be the threshold where a CEO is going to say, okay, I should let the board know about this. Right, because it's material, because it could impact our results for the year, it could impact our strategic initiative that we've been talking about and working on. That it has a material that how the dispute gets um, litigated, worked out, whatever side it comes out on, you win, you lose, like it could really make a difference. So you're taking that to the board. Hopefully, you're taking it to the board early and you're saying, hey, I just want you to know this is what's going on. This is our plan. This is how we plan to handle it. We've engaged outside counsel to look at it for us. They're working with in-house counsel, or we just got the complaint yesterday. We haven't hired outside counsel yet. But at the end of the day, when it's early, then you're letting the board know, and the board, because they hired the CEO, the CEO is responsible for what happens underneath him or her. The buck stops with him or her. And so the board is probably going to say, thanks for letting us know. Good luck with that. Keep us informed.
Hmm.
Um, and and that to me would be a best practice is you don't want to surprise somebody. You don't want to, let me put it this way. If your board is surprised because you're telling them about stuff that's late, that's not what I would call like a long-term job security strategy. Like, you want to let them know early and you let them know you have a plan. Um, but further along the way, once you get into things like, let's say you're on the side of you're a defendant and you think, this could be very expensive for you. You have to get your board involved, right? You have to get them involved because they need to bless a settlement, which is what I would call not even close to being within the 2026 budget, if you will.
Hmm.
You want them on your side, so it's like everybody's putting their hand in the fire. The last thing you want to do is say, yeah, I settled this case. I signed with my authority on behalf of the company. We're going to be paying X number of dollars, and oh, I'm letting you know that happened last week. Yeah, that's not good.
It's really managing expectations and
It's all about managing expectations at that level. And
so
by
then
the way, I would go further. I would say if you bring that down through the relative ranks, I think you always want to manage expectations, whether you're, a coordinator, a manager, director, VP, you always want to manage expectations of the person that, you're reporting into.
I
So
think
no one likes surprises.
I think it's a great observation, having sort of worked in-house myself and then been in firms that each organization, to your point, is an organism and has its own internal dynamics that have to be managed like that within a law firm versus in-house also. And you sort of
Yeah.
your insight, you really don't understand it.
The problem is that like there's this thing that like humans don't like to deliver bad news. Like
Yeah.
no one wants
In
to be
Hollywood.
anywhere, right? Because there's this idea that if I'm delivering bad news, somehow I'm responsible for the bad news, right? And so and those, that's an environment that there can be a lot of problems in environments where the bad news is getting swept under the rug. Right. So hopefully there's an environment where it's all, everybody's, on the same team and they're just trying to figure out how to fix the problem.
And that makes me think of something you spoke about earlier, which is cultural considerations, both internally and externally. And I know that you also have a deep background working in Latin America. And I just wonder, from your perspective, uh, what's your view on navigating these cultural considerations across cultures, not just as a business executive, where you know the maybe the customs and how people work, but you're a mediator as well. I imagine this must come up when you're trying to settle cases.
Yeah. So a lot of my work has been done in Latin America and even in the U.S., I ran a Hispanic cable network, and then I worked at a large Spanish language broadcaster. So there's a really interesting cultural element there, and that is that American culture is much more team oriented. It doesn't mean that you don't have authoritative managers who tell people, go do this, go do that. But there is this expectation that if you're in a meeting and someone says, hey, okay, let's have a discussion about this. What does everybody think? Let's go around the room. People are gonna, raise their hand, they'll give their opinion and I think this or I think that, or we should consider this or we should consider that. And that's all um, not only expected, it's encouraged. And in Latin culture, it's much more hierarchical,
Mhm.
almost patriarchal. And so there's a greater level of deference to someone who is older than you, someone who has a title to you, certainly someone who's male versus female. And so it can be more challenging to get somebody to give you their genuine opinion about something, and to give you information, quite frankly, that you need because the communication path can be traditionally much more one way from top down, and it's harder to get the communication going up the chain.
It's interesting. So yeah, I imagine when it comes to resolving your disputes, it's a key consideration in terms of how you explore these things. But I mean, you're speaking about the Latin American culture, but being in business, it must be something you think about across all the different cultures that you work with. I mean, entertainment is such a global business now. I think it's probably a more important a consideration than it's ever been.
Look, I think litigation is teamwork, right? You need to have the teamwork going on, within the law firm, with in-house counsel or directly with management. And when everybody's on the same team, your things are going to go better, right? Because you're surfacing the information, you're surfacing the challenge, you're making efficient decisions. There isn't the same amount of second guessing later. And so but that you have to have an environment that promotes that. So the same concepts of what I'll call respect for your peers, respect for, that, your opinion might not be the best opinion. There's a one way to think about it is crowdsourcing, right? Crowdsourcing the answer among members of the team is the best way to get to the best answer, as opposed to a guy sitting at the head of the table. Usually it's a guy, hopefully not always, and says, "Oh yeah, this is what we should do," and everybody go do it. That in my view, that is it's not only not a fun environment to work in, it doesn't typically lead to the best answers.
Well, and it also sounds like one of the key takeaways from your presentation today is, from the perspective of the in-house business executive, is where are we actually trying to go as a team? What is the strategy of the business that needs to be understood that it sounds like you're kind of constantly keeping your eye on?
You have to. And so that's just, what I did as an outside lawyer and an in-house counsel is I just spent as much time as I could reading at the time. It was the trade rags, reading everything I could about what was going on in my industry, lots of things that had to do with companies that I wasn't working for, so that when I was in those conversations, everything would make more sense because I wanted, when I was sitting in the room with lawyers, I wanted to be able to understand how the lawyers were, how the business guys were thinking about things, and what the basis of their decisions were. And much of that is what I would call a result of the commercial ecosystem. So and I ended up, I guess that's why they kicked me out of the legal department and told me to go do something else in the business. So I think it worked, as for me. But yeah, the best lawyers are your partners, they're your team members. They understand what you're going through as a client.
Well, look, I can see why they would have put you into that chair. Clearly, you're an expert in this area, and I think that another key takeaway from your talk, I think, is that sometimes the best experts are the ones who are sitting next to you as your clients and as the business executives that you're working with in-house as well. So we're at the end of our time for today. So unless you had any additional thoughts you wanted to share, I wanted to thank you on behalf of the Beverly Hills Bar Association for your presentation today. It was tremendously valuable. And thank you so much for offering your expertise today.
Thank you, David. It was a pleasure to be here.
Thank you. Thank you, Michael. Thank you, everyone, for joining.
Okay.